Good morning. Welcome to the Utah Court of Appeals on Halloween. We're glad you're here with us. A festive orange tie over here, and yeah, I like it. No costumes though. Yet.
I was told not to.
Anyway.
Probably sage advice.
Probably good.
I'm Judge Ryan Harris, and with me are Judges Michelle Christensen-Forster and Amy Oliver, and we're happy to be here to entertain your arguments today. In the case of, in the Adoption of K.R.S, it's case number 2023-0712. If I could have counsel enter their appearances to start with here.
Thank you, Your Honor. Jason Richards and Alexander Marshall for the father.
Good morning.
And Mark Nelson and Jessica Anderson for appellees, mother and stepfather.
Good morning to you as well. All right, looks like 10 minutes on the clock, so that's been communicated that 5 is for rebuttal. Any other questions before we begin?
I don't think so.
Okay,
No.
we look forward to hearing your arguments.
Good morning. We are here to address a private termination of parental rights appeal that occurred in district court. This is an interesting case that occurred where the termination occurred by a procedural default against the father. The first issue that we are addressing is the finality of the order for purposes of appeal. In any context, an order terminating parental rights is a final and appealable order. The first thing to look at when determining whether or not a district court termination is final is the statute itself. So as a threshold matter, 78B 6-112-3 states that a court may enter a final order terminating parental rights before a final decree of adoption is entered. We believe that this shows that the legislative intent, by calling a termination a final order, makes it an appealable order as well.
So are you suggesting that 112.3 is a statutory exception to the final judgment rule?
No, I believe it's in line with the final judgment rule as it applies to these types of cases.
All right, because I'm looking at page 22, 23 of your brief. You do have a section where you talk about, you think there is a statutory exception to the final judgment rule, and you referenced 133.7D. But I don't see you making the argument that 133.3 constitutes an exception to the final judgment rule. So I want to understand, 112.3, excuse me. I want to understand that argument a little bit better. How do you think that statute gets you where you want to go if it's not an exception to the final judgment rule?
So our position is that it is not an exception to the final judgment rule. It is in line with the final judgment rule for termination cases, whether they're in juvenile court or in an adoption case. So the final judgment rule in civil cases, as is pointed out repeatedly in juvenile court termination cases, is that finality is determined the same way any other finality rule is in any case, that it dispenses of all the rights and obligations of all the parties. And so a termination case, whether it's in juvenile court or in district court, ends in a termination of parental rights. So the father's rights, the parent's rights are terminated and disposed of.
Well, we have a ton of case law that talks that speaks to this, that the finality of judgments is looked at a little bit more flexibly, I think is the word used in the case law, in juvenile court than in district court. We have somewhat different rules for these two different courts. And here we're in district court. And so I guess I want to understand this argument you're making. Is it that you think we should apply juvenile court flexibility in this situation, even though we're in district court? Or is it you concede that this is not a final judgment, but you think 112.3 is a statutory exception?
No, I don't concede that this is not a final judgment. I believe it is a final judgment. It's in line with the finality rules. And I don't know about more flexible in juvenile court, but finality happens more in juvenile court, right? Because the finality rule specifically addresses when there's a permanent change in the status of the child in child welfare cases. I mean, that's very clear that that's what the rule is. And we think that rule should be applied here because it's the same basic theory that when a child's status is permanently changed, that creates finality for that child and creates a right of appeal. And so,
but here, given that we're in district court and operating under the Adoption Act, a district court, and this is my reading of 112.1, a district court only has jurisdiction to terminate parental rights in a child if the party who filed the petition is seeking to terminate parental rights in the child for the purposes of facilitating the adoption of the child. So doesn't that, just by its plain statutory, I did add the word only, but by the plain statutory language, imply or the understanding of the reading of that is that there has to also be an adoption, especially given the definition of adoption in the Adoption Act?
Well, so I believe that there are two final orders in an adoption proceeding. If it involves termination of parental rights, that creates a final order for that separate proceeding, for that separate petition. I mean, when you file an adoption proceeding, you still have to allege termination of parental rights. You still have to either join it with your adoption petition or file a separate petition itself. And that's what happened here. You have a separate petition filed within the adoption case.
I'm not sure you could file a separate petition for termination of parental rights in district court, could you?
Well, it's interesting. The
Without an
statute sort
adoption?
of reads that way. The statute reads, and I think it's the same one, 112, reads that you can file a petition to terminate parental rights before you file the adoption petition or after you file the adoption petition.
But doesn't there have to be an adoption petition? And I guess sorry, I'm not letting you answer the question,
okay.
but hypothetically, let's just say there's a petition for adoption that includes a petition for termination of one of the natural parents' rights. What if that adoption doesn't happen?
Well, that's exactly our point. If that adoption doesn't happen, and that's what triggers the parent's right of appeal, then the parent is just left in the wind, not being able to appeal or receive any redress for
But
the
they
termination
could
of parental
appeal.
rights.
You can get a Rule 54B certification, right,
sure.
at any time. So if something happens with the adoption and doesn't go forward, then the parent whose rights were terminated could ask for a Rule 54B.
I don't think so, because the statute says when a parent's rights are terminated in an adoption proceeding, they are no longer entitled to notice, they no longer have the right to counsel. It's not like you can just hop on Exchange and look at an adoption case, and you can't. They're private, they're sealed.
But what's stopping you from going and asking the judge to certify that order as final under 54B?
I suppose nothing is stopping you from doing that, but it's a discretionary thing. The judge could say no.
Yeah, well, the Rule 5 train has left the station. That's 20 days after the order.
Yeah.
But even today, you could go down and ask, I guess it's not Judge Bagley anymore. He's retired, I think.
Oh, I don't know that.
Whoever's manning that post, you could ask that judge tomorrow to certify this under 54B, right? There's no time limit on that.
I don't know. I don't believe there's a time frame to ask for that. But, and so it is true, a parent, but that is again the difficulty, is that the parent loses the right to counsel after termination. And so the parent would have to go file their own pro se rule.
Yeah, you said that in your brief, and I want to explore that with you because
Sure.
you all are now representing father here. There is a right to indigent defense counsel even on appeal in these cases. So
Sure.
help me understand your statement that they lose the right to counsel after the order's entered.
Well, if they file an appeal, they do have the right to counsel because they have appellate counsel appointed. But under this scenario, if there is no right of appeal at termination, then we would not get appointed to that case. You wouldn't have appellate counsel if there's no right to appeal. So generally, a Rule
You're
54
saying
motion is sought by trial counsel.
In your view, it's not
There's a
not part of trial counsel's job to assess whether a Rule 54B motion should be filed?
No, I believe it definitely would be.
I think it is too.
Yes.
Yeah. So I mean, this is a very strange scenario, and maybe we can talk about the merits in a minute, but it seems like in 99.9% of the scenarios, there will be some attorney able to guide the parent whose rights have just been terminated as to what that parent's rights are vis-a-vis appeal, right?
Yes, and that would have been nice to have that here, but counsel withdrew. And so our client had no attorney when his rights were terminated. And so that's also part of the issue here.
Do you have any case you can point us to that relaxes the final judgment requirement as you are proposing here in district court?
As far as I know, this is the first time this has been addressed on appeal, a termination order.
So I take your
in-
point that there's a bunch of cases that say a termination order in juvenile court is final because it ends the relationship between parent and child and,
Sure.
goes through that factors. But again, maybe it's just my understanding and you can comment on that, but my understanding is in juvenile court, finality is somewhat more flexible than it is in district court. In district court, we have a definition of what's final, and that is that something needs to resolve all claims by all parties before we have a final order.
Sure.
And I'm not aware of any case relaxing that requirement in district court. If we were to do that here, I think we would be the first. Am I right about that?
It is the first time this has been addressed, one way or the other.
Well,
So-
not just this, but in any context, anybody would have watered down the final judgment rule in district court, right? I'm not aware of that in any context, not just this one. And that's why I'm asking. If you have that authority, I'd love to see it.
And I mean, the motion to intervene is the only one that I'm aware of that creates that sort of final order when a motion to intervene is denied. And then that creates a right of appeal. But no, I don't have any other, I mean, I haven't exhausted all areas of law researching this finality rule. But as far as I know, and it goes the other way. There is no case that says a termination order is not final in a district court adoption.
But we do have statutes that in other contexts and other acts provide express rights of appeal from points in the litigation that are short of the final judgment. So I was looking this morning to see, what was out there. And for instance, in the Uniform Arbitration Act, there's a list of A through F of all the things that you could take an appeal from, right? And one of those is admittedly the final judgment, but there's a handful of other orders that happen along the way where the statute has expressly said you can appeal from those orders. So we don't have that here, right? We don't have language that says, yes, you can appeal from an order in district court that terminates parental rights.
Correct. There is no direction given to us. But I will say in juvenile court, it's the same thing. There's no direction given to juvenile courts on what type of order constitutes a final judgment. That's something that the courts have created. I mean, there is a statute regarding appellate rights in juvenile court cases, but it just says that a parent or a party can appeal a final judgment in every subject matter that is addressed by the juvenile court. So
Does it matter, this goes to a question asked earlier, does it matter that in district court, you can only terminate parental rights in the context of an adoption petition, where in juvenile court, you can terminate parental rights without a pending adoption, right? So there is a difference in terms of both the procedure and the substance there. And I'm wondering, is that why maybe this is different, that you can't appeal from the termination order because there has to be an adoption in district court?
no, I don't think that's the reason, because in both cases, there's no final disposition for the child yet. I mean, in juvenile court, the child, there's still review hearings, most of the time it's an adoption. That's true, but sometimes there's not. And it's the same in district court. There is a pending adoption and the child's permanency, if we want to use that term, is not finalized yet. And it can create some pretty not so absurd results. I mean, I have done this a long time and have seen a lot of crazy stuff happen after rights are terminated in an adoption case that significantly delays finalization of that adoption. And so that's why it's really prejudicial to the parent not to be able to appeal right when their rights are terminated. Or, I mean, yes, you could seek a Rule 54 certification, but we believe there's a right to appeal a termination order right after the order is made.
So, go ahead.
I just wanted to get your take on, in the matter of the adoption of BH, which is a 2020 case from the Supreme Court. And the court talks about the difference between the Termination Act in juvenile court, Parental Termination Act in juvenile court, and the Adoption Act in district court. And Justice Peterson talks about, in paragraph 43, she talks about how the two laws are different, basically, that they provide for substantively different proceedings. the proceedings are similar in that the grounds for termination are the same under both acts. The Adoption Act cross-references the factors that are found in the Termination of Parental Rights Act. But because terminations under the Termination of Parental Rights Act do not necessarily include a permanent placement for the child, that act contemplates continued juvenile court review hearings until a permanent placement is found, and it does not completely foreclose reunification. In contrast, when parental rights are terminated under the Adoption Act and the court enters an adoption decree, that act does not provide for continued court involvement. A new parent-child relationship has been formed, the former parent's rights in and obligations to the child are extinguished, and there is no provision for reunification with the parent whose rights were terminated. So rather than sort of combining these two acts or recognizing the similarities, hasn't our Supreme Court already acknowledged that they are different, both in their procedures and in the outcome under both?
No, and I'll explain why.
Okay.
So BH particularly was concerned with the UCCJEA subject matter jurisdiction for adoptions and terminations. I mean, that's the sole focus of that case.
Right.
But I think that you know, the holding or the dicta or whatever we want to call it in that case, I think only supports our position that termination should be a final order in both forums, because in both cases, in both forums, finality, the finalization for the child, so final placement for the child, hasn't happened yet, right? And that's true. There is ongoing reunification, or not reunification, review hearings in a juvenile court case.
But if finalization hasn't happened for the child yet,
in both forums.
but how do we have a final order? How do we
Well,
have a final judgment?
So
Because you have
Right.
to, in order to have a final judgment, you have to deal with all of the parties and all of the,
and that's why I believe, for purposes of like finality, a termination proceeding in district court it has to be treated as a separate proceeding. I mean, if it happens this way. I mean, I've seen adoption cases go through, you know, to the adoption finalization hearing, and that's when rights are terminated, and that triggers the right of appeal. And that's where the statute says you can combine an adoption and a termination together. That's, I believe, how it's supposed to proceed. But when you file a separate adoption, termination petition within the adoption, that creates a separate proceeding. I mean, you've got more discovery that happens, you've got its own independent trial, everything happens separately. And so that case resolves the action as to all parties in that proceeding. You know, just like it does in juvenile court, and just like it does in district court.
Are you aware of any case law that defines proceeding that narrowly? Generally, proceeding or action, I think 54A talks about action. The action is everybody, all right, generally for appellate finality in district court. Are you aware of any case law that defines proceeding or action narrowly like you've just done?
No, but Black's Law Dictionary does. I mean, and so that.
I mean, I take your point sort of as a policy matter, that this is the way it probably should be. Like, there doesn't seem to be a ton of policy sense to treat these orders as non-final in district court, yet final in juvenile court. That makes a ton of sense to me. But we're not policymakers. We've got to plug this into the law as it currently exists, and that's the problem I'm seeing here.
And I'll push back a little bit, because I'll say you three are the ones, not you three specifically, but appellate courts are the ones that created finality in juvenile court. There is nothing in the juvenile court code that I'm aware of in the past as well that creates final orders. I mean, that's something that our case law, our common law has developed.
I take that point too, but we aren't writing on a blank slate. So Judge Christensen Forster asked you about BH. I'm going to ask you about CC, which is the Supreme Court case from 2021. I realize that didn't involve a termination order, but the court says a bunch of things in here that seem adverse to your position, and I'd like you to comment. They say an order of parental termination may trigger an immediate appeal of right when entered in the juvenile court, but the cited statute applies only to orders entered in the juvenile court, and they're differentiating between juvenile court and district court. And then they say, once the father was allowed to participate as a party in the district court adoption case, he was on equal footing with all other parties. His subsequent dismissal thus could not produce a final appealable order if the order dismissing him adjudicated fewer than all of the claims or the rights and liabilities of fewer than all of the parties, meaning everybody to the action. Again, I know that case didn't involve a termination order, it involved a summary judgment dismissal on other grounds. But how do you square CC with the position you're taking here, and how do we sort of get around that where we're bound by what they say, and they've clearly signaled there's a difference between juvenile court finality and district court finality?
So I think you get around it because there was a termination in that case. I mean, in that case, so a dismissal through partial summary judgment, I mean, there's a lot of case law regarding whether that is not a final order for purposes of appeal. And so I think that's why in CC, the Supreme Court didn't find that was a final order. The termination's the final order, we believe. And the termination in that case in CC happened at the time of adoption. I mean, there was a termination order in that case. And it only references it in passing, and so I'm assuming there was a birth mother or that this father's rights were actually, abundance of caution, they just decided to terminate it at the time of the adoption. And so there was a termination order
I think
in that
mother
case.
relinquished, or she actually put the child up for adoption, right?
Right, that was the situation, but it does reference that there was a termination order. It happened at the time of the adoption decree. And so I just think the CC is related to that specific fact scenario. That finality in that purpose was because one portion of the Adoption Act wasn't met as to that father. I mean, I think the district court held the marriage wasn't valid, and so that there was no putative father, and that was the issue that they disposed of. But again, I share the same concern, like practically, a person who's terminated, and I don't know if it's different for dismissal, it probably is different for dismissal, that you still have the ability to watch the case and follow it to its conclusion. That obviously happened because this father appealed after the adoption happened. But here, when your rights are terminated, you are no longer entitled to notice, you are no longer entitled to be involved in the case, and that is a distinction between the two scenarios, is that termination of rights has a very real chilling impact on the parent procedurally in that case to even be involved in the adoption. Well, my time's up. I didn't get to any of the stuff regarding default, but unless I have any other questions, I don't think I can continue.
Any other questions? Okay, thank you.
Morning, Your Honors.
Good morning.
I think that the court is right to zero in on BH and CC. One point that I would make at the outset as to just finality, I mean, we would concede that the termination order does say respondent's parental rights and obligations over the child are permanently terminated from this date forward. So that's just one of the facts in this case. But in terms of reading the 78B-6-112.3, and a court may enter a final order terminating parental rights before a final decree of adoption is entered. I would say that happened here, but that doesn't change the obligation to certify it as a final order for purposes of appeal or to do an interlocutory appeal like was alluded to earlier.
Well, let me ask, is an order of termination always final? I'm trying to figure out why 112.3 uses the word final order, right? So it says the court may enter a final order of termination. Why is that different than an order of termination? Wouldn't they be substantively the same?
I mean, that's a good point. One, as I've been thinking about this, it's almost analogous to like a bifurcated decree of divorce. So that's a final order as to like if divorcing parties settle custody issues and enter a bifurcated decree, that's a final order. But the appeal wouldn't start until all issues as to all parties are resolved at the end of the case. So,
Well, that's a final order in what sense?
a bifurcation order.
Yeah.
Well, final as, but could still be modified prior to the final order resolving all parties.
Yeah, you're not suggesting it's a final order for purposes of
I'm not.
appealability.
Yeah, no, not. but it's analogous in the sense of, I think the way the statute reads, a final order, it's not like a final decree, a final judgment. At least that's the way that I reconcile this language, that it's a discretionary, number one, and that discretionary implies that another process might have to take the next step, like certification under Rule 54B.
So in this case, the trial court could have done the proceedings together, meaning the termination hearing and the adoption petition could have been decided
In one hearing.
in one hearing
So-
or at the conclusion of that hearing, right? It could have been in a single proceeding and a single order, right?
Correct. The district court has a lot of discretion in how it manages its docket, and theoretically possible, yes, you could have a hearing like that. Here's the practical reality, because we've done these before. You want to do a termination case to terminate what we would consider the unfit parent, and get that parent removed, so that then the adoption hearing is a completely different dynamic for this child, whose the best interest is always the focus. So it's a celebratory adoption. It's moving on and having stability in that child's life. So combining a termination hearing with the adoption hearing is just fraught with peril in my mind, and for the best interest of the child. And I know the child can be excused from maybe a certain part of that hearing, but then you're ramping up, and so there's also this judicial efficiency argument too, where you're ramping up to terminate. Maybe that doesn't get granted, and then you still have this adoption that you've already prepared for. So I think it's more efficient and appropriate to terminate first, make sure that is locked in and done, and then have another hearing where different issues, different priorities can be addressed, and including the best interest of the child.
This is going to be a silly question, but could you file as a separate proceeding, a petition to terminate parental rights
In district court?
in district court?
Not that I'm aware of. I think the only jurisdiction for the district court is as it's laid out in the statute, where it's in the context of an adoption, where the court already has jurisdiction for an appropriate adoption, and then you can bring it in the context of
And would the order terminating a parent's rights, if, let's just say the adoption doesn't, something goes wrong and the adoption doesn't go through, would the termination of the parental rights still be done, final?
well, so the first, just a couple
Would that
of
be a final
thoughts.
judgment
Right, so.
without an adoption?
And I was thinking about this as questions were being asked earlier. So the district court will manage its case. It's not gonna just let an adoption sit indefinitely. It'll resolve it one way or the other. And then as soon as there's a final ruling on, either the case gets dismissed and then the appeal is triggered, or there's a final ruling on all the issues as to all parties. So that's when that's why, frankly, I think this appeal is premature. And that's consistent with CC, that all issues, he's an intervening party, and that's what happened here. Father intervened. He's a party, one of three parties at least. And until all rights as to all parties are resolved, that's when the appeal is triggered.
But I think as a practical matter, maybe this is what the question was getting at, is so you proceed with the termination and the orders enter terminating parental rights. And then the next step is the adoption, but there's a legal defect that prohibits the adoption from going forward, right? The person petitioning to adopt can't meet the legal requirements to do so. So the adoption has to be denied. Then we've got a situation where parental rights are still terminated, right? That doesn't undo the termination order.
That's right. Unless it's appealed.
And until that time that the adoption is, the petition's denied for the adoption, the terminated parent wouldn't have a right to appeal under your view, right? So let me ask a practical question then. One of the points being made is that the father, excuse me, can't participate in the proceedings once termination occurs and isn't entitled to notice. So setting aside a 54B that could happen at that time, how would the person whose rights have been terminated know if the adoption didn't go through?
Right, and that's the most closely analogous case that I'm aware of is in the matter of CC, where the party that was the intervening party who was dismissed still got notice and as a practical matter did it.
But that wasn't a termination order, right? So a
That's right.
termination order is somewhat unique,
I understand that,
right?
yeah,
But where it literally closes the door
right.
and says you're no longer entitled. And the point made that adoptions are sealed is correct, right? Those aren't just public records that anybody can log in and check. So I'm just trying to figure out from a practical standpoint, if there is some problem with the adoption petition itself and it can't go through, how does the person whose rights were terminated ever know that that happened so that they can appeal?
Yeah, as a practical matter, when counsel of record, so assuming he had counsel of record, and not only did, although the indigent appointed counsel withdrew, there's in the record, the representations by the father to his appointed counsel that he'd hired a private lawyer. Private lawyer never appeared, but anyway, it's not completely clear that he doesn't have counsel based off of father's concessions or speaking with father or to his lawyer. But as a practical matter, a counsel of record could, unless they withdraw, are still gonna receive electronic notifications in the district court. It's not like the juvenile court system where it's a much more closed system.
Is that true, though, even if the party's terminated from the case? I mean, maybe this is a technical IT question, but it seems to me, just from a logistical standpoint, that if the party is terminated from the case, that terminates the lawyer as well.
I think there's this, does it terminate the lawyer? I don't think it terminates the father's ability to have counsel through the process to the end of the case. I don't think that's what's contemplated when you're appointed counsel in this context. This is a technical question, but my understanding would be that if a party's rights are terminated, absent some extra action to turn off electronic notification or notice, then nothing's gonna change with respect to notice.
So, again, I don't want to get too deep into the policy woods, but can you suggest a reason why we might want to have termination orders be non-final in district court, yet be final in juvenile court? And what sense does that make?
Well, we can speculate or have different policy concerns, but one issue would be that the legislature hasn't said that it hasn't made termination orders in this context appealable, right? So, but it is in terms of.
Well, but their point is the legislature didn't make them appealable in juvenile court either, the Supreme Court did. And that's, I think, the point that was just made a minute ago. So why can't we do the same here?
Well, you'd be writing new law. I think that's clear. I don't have a perfect policy answer for the question. I mean, in some ways, it'd be nice to have termination orders be permanent so that it gives finality to the parties and can move on and go forward. But I don't have a perfect policy answer other than, that it's a juvenile court standard. There's law that says we don't apply, the Adoption Act doesn't wholesale incorporate the juvenile code or juvenile law that's applicable. So it's certainly not incorporated at this point. And I think
let me ask a different question. Is sort of gets to the same point, but in maybe a more practical way. Let's assume that tomorrow these guys go down to Manti and file a motion for Rule 54B certification before the judge who's currently sitting in that post. Would you oppose that motion? And if so, on what grounds?
Well, hard to speculate because that motion hasn't been made.
Right, but what grounds would you have to oppose that motion, right? It would be, they would say, look, these are completely separate issues, these are collateral, they don't have anything to do with what remains in the case. This is a perfect candidate, there's no factual overlap between what remains in the case and this one. This is a great candidate for Rule 54B certification because it meets all the requirements. Your response would be?
Maybe it is a good candidate. Frankly, I'm not sure there are a lot of good grounds. But the bottom line is that it wasn't, and so and that's why we're here today. So, if there's other questions, I'd be happy to address them, or I could make a couple other brief points. Okay. I do think that the notice issue is one of the more, complex issues. I would agree that that's a nuance that is unique to this case. But with respect to default, default in these circumstances, I mean, and it's related to this ineffective assistance of counsel claim, which I think is a red herring. So you have a party who is engaged in litigation, mediates with his court-appointed counsel, and then stops communicating. So this is not a default in a traditional sense that he wasn't participating at all. This individual was warned multiple times by the court and his counsel, and chose not to engage. There's a finding from the lower court that either Mr. Shipp knew of this hearing, knew he was supposed to be here in person, or he's intentionally preventing himself from knowing, and so I'm going to enter default. So this is a unique case where you have the juvenile court considerations that would not allow default, but in these circumstances, it's a unique case where default is appropriate and justified. And there's questions about the harshness of the remedy. So you have I think everyone would agree that termination of parental rights is harsh. But at the same time.
Explain to me what the default mechanism was. Generally, default is a situation where someone doesn't answer.
Mhm.
Father appeared, answered, filed pleadings,
That's correct.
and those pleadings were never stricken,
That's correct.
as far as I know, as some kind of sanction for not showing up. So the word default in this context seems like a little bit of a square peg in a round hole. Help me understand the way you're using it here. How was this a default?
Well, the court warned Mr. Shipp that the court would order default for him not being there. So I mean, in terms of,
What does that mean in this context?
well, I mean,
Someone who's already appeared and answered generally can't be defaulted unless their pleadings are stricken as a sanction.
and I'd have to review the record. My recollection was that there was no formal answer actually filed. There was talk of an answer that's coming. I'd have to check the record.
There's an answer.
Oh, strike that thought. So I guess, are you parsing out the technical issue of whether pleadings have to be struck in order to enter default?
I think that's true, isn't it?
Well, so I guess I would say that the default that the court entered implicitly struck the pleadings.
Or I guess you could take the position that the word default is just a misnomer here. And there really wasn't a default. He ordered a hearing be held, and somebody didn't show up. The court then proceeded without him.
That's right.
And that's not a default, right? That's
Yeah.
just proceeding with one side not present.
That's true. And as part of the record, Mr. Shipp, even though he was not entitled to receive notice, continued to receive notice from the other side with respect to a notice to appear or appoint, the proposed findings, which were never objected to. So at any rate, he was involved in that process as well.
I mean, the distinction I'm trying to draw, just so everyone's clear, because these issues we're going to have to deal with them at some point, right? There's a difference between striking somebody's pleadings and saying, okay, now you don't have a pleading. I'm just going to give the plaintiff what they're asking for without really looking at the facts, because you haven't answered and you haven't responded, and so I'm not really going to look at the facts. I'm just going to give you what you're asking for because you didn't answer. That's what we do. That's a typical default scenario here, right?
Yeah.
That's scenario A. Scenario B is you schedule a bench trial, hypothetically, but only one side shows up. Okay, so the one side puts on their evidence, the other side isn't there to put on any counter evidence. The court then makes factual findings and draws conclusions of law from the one-sided evidence the court's received and enters an order. That's not a default, but that's a one-sided proceeding.
Right.
Which scenario are we closer to here?
This scenario is a bit of a hybrid because the court did make the most complete findings that it could in light of the party not cooperating with discovery. So and with the hearing. So from this perspective, you have one shot at trial on the merits, more or less, right? So, and it's the burden of the people who want to terminate to establish the evidence to terminate. So subpoenas are issued and teeing up a deposition of father, and then father stops communicating with his lawyer and is absent. We have a trial date, and so the terminating parents have this dilemma of how do you resolve this in light of the court saying default, but if you go to trial and father suddenly re-engages but hasn't cooperated in the discovery process, your one shot at a trial on the merits is potentially in peril. I mean, maybe the court would continue the trial or something like that, but there's no guarantee. So I guess the short answer is what happened here is a bit of a hybrid because there were findings that were made. The defaulted party was still given adequate notice and opportunity to object to those findings, and never.
Yeah, and here the findings weren't made on the basis of the allegations in the complaint, right? As I understand it, the findings were made based on an affidavit and some criminal record documents that were filed, right?
Right, so consistent with the allegations in the complaint, but yeah, there was a separate evidentiary basis to get, those in. So it was an affidavit plus records that were, admissible, so. Unless there's other questions, I will end. Thank you.
Thank you.
I wanted to be clear about one issue is I don't want to appear that I'm saying that the court can't do an exception to the finality rule. I mean, I think it can, and I'm not abandoning that argument. So we just believe as a threshold matter, a termination order is final across the board, whatever forum you're in, because it adjudicates the rights of all the parties to that termination petition, that termination case. But recognizing that the case law is different, the case law that does discuss finality in the child welfare context, changing the permanent status of the child, those are exclusive to juvenile court. And so I think the court could create an exception or apply an exception that makes this a final order for purposes of appeal, because it is a unique situation. It doesn't happen often. That's why in my view, I haven't seen any of those cases come up before. And so it could create an exception to finality for this limited purpose in the event of a contested adoption at the termination stage. But unfortunately, I think you all are in a position to make law on this because there is no conclusive direction from the Supreme Court in regard to a termination order in a district court adoption case. Now, we can differ on, no, we're just applying it to the existing finality rules in district court civil cases. But this would be the matter of first impression that says termination is not a final order in district court. So that is what we're talking about here. We're not talking about only creating new law by saying it's a final order in district court. Because, again, our position is that it's already a final order. The statute says it's final, and it should be treated as final for purposes of appeal.
Well, either way,
Yeah.
that we decide, right, we'll be
Yes.
making law.
Yes, and so that's why I wanted to respond to that we're not the ones inviting you to make law. That's just the issue. It's a matter of first impression as far as I know, and that's what the issue is. To respond very briefly to the default question, in our view, this really is a default situation. I mean, yes, there was and that goes to our argument that it was improper to hold father in default, but that's what the district court did. It specifically made an order that father is in default because he did not appear. It happened in a period of two weeks.
But what does that mean in this context?
So in this context, it means that
His pleadings are stricken?
well, that's basically what happened, because the final order in this case, and I get there was an affidavit filed, there were some police reports filed, but the affidavit's very similar to the termination petition that was filed in the case, and so.
Right, but the difference is it's sworn. It is evidence.
It was a verified petition. I mean,
Was it?
Yes.
I didn't check that.
Well, and isn't the difference that the district court entered findings of fact and conclusions of law? Because if you're just gonna default someone and strike their petition, you don't have to make any of those findings. You just essentially grant the petition and then order the relief that's been requested, right?
I often get Sorry.
It's a little bit, it strikes me that it doesn't quite fit the default box.
Well, in these cases, in my opinion, the court has to make findings, even in a default situation. And this just may be a practical thing, but I often get pushback from court clerks in like divorce cases when there's a default and I submit a decree. I say, no, we need a finding of fact here. And so the difference is, and this goes to the substantive direct appeals of default orders, is that you have to, the only way you can really appeal a default is, was the default done properly? And in this case, I don't think it was. Dad had less time to appear in court than you would have 21 days for notice of appear and appoint. It happened very quickly, a period of 2 weeks, and he's defaulted. But, so you can challenge that, but you can also challenge the substance by saying the well-pled facts of the petition do not support the relief that is being sought here. And that's what I think ultimately the fatal error is that the final order in this case is utterly deficient when it comes to termination of parental rights. There's very little having to do with best interest of the child. This court's opinions in LLB and I know the last name, I don't want to say it, the JE case, all are identical to this case with step-parent adoption and a problematic finding in the district court that best interest findings related to the relationship the child has with the stepfather is insufficient as a matter of law to terminate parental rights, because there's nothing that child's relationship with the stepfather changes at all with adoption. Those are things that are presently happening before the termination takes place. And so substantively, as a matter of law, the petition to terminate and frankly the affidavit that was filed is insufficient to support termination of parental rights based on our case law.
On the best interest prong.
On the best interest, yes, there's enough evidence as to grounds. We'll concede that. But on the best interest prong and the strict necessity part of the best interest inquiry is utterly insufficient.
And that's another question I had about, I guess, differentiating the termination of parental rights in juvenile court versus adoption proceeding involving termination of rights in the district court. The fact that the legislature included a strict necessity requirement in juvenile court and did not specifically include that, has not specifically yet included that in the Adoption Act, doesn't that signify that they are two different proceedings?
Well, I'll grant you that there's litigation involving that, for sure. That issue's before the Supreme Court right now as far as strictly necessary goes. But as to that issue here, that's not something you have to decide, because strictly necessary is pled. That's one of the factors that's pled in the termination petition in this case. It's one of the findings that the court made in this case. So that's not an issue that needs to be addressed, because it's invited error if
I guess
that
the
is going to be
context of my
challenged.
question is
That they're
yes,
different.
you can appeal, a parent whose rights are terminated in juvenile court can appeal that immediately because it has affected, it is a final order as elucidated by the Supreme Court. Here, when we're operating under the Adoption Act, because the proceedings are different, because they're different proceedings, don't we have to wait until a final order of adoption is entered before the proceeding itself is final?
No, in that the two forums are unique in that there is a core proceeding, right? There's a core proceeding in the juvenile court. There's a child welfare case that began with an abuse and neglect petition. Mm-hmm. Here, there's an adoption case that began with an adoption petition. So there's a core proceeding that initiates the action. Within that action, there are other proceedings like a termination petition. And in juvenile court, that happens more because there's, not that much more. There's a very limited right to appeal a permanency order, but that's in my opinion, that never happens. Very rarely happens. So really, you've got two things that happen in juvenile court: the initial adjudication appeal and then a termination appeal. And here, it's similar because it creates a core proceeding and then a termination petition within that proceeding that should be final for all the same reasons that we've argued. It adjudicates, and I think it's in line with the final judgment rule. And all the juvenile court case law that discusses finality starts off with saying that it's finality in juvenile court is the same as it is everywhere else. It adjudicates the issues of all the parties.
Same but more flexible.
Same-ish, we'll say. And so,
Same but different.
but for here, I'm not saying like a pretrial motion filed in a termination case is an appealable order. I mean, that's an interlocutory issue. Even a shelter hearing is an interlocutory issue. A temporary custody hearing in an adoption case is an interlocutory issue. But termination that's final. I mean, it would, I think, significantly rock this area of the law if it's not final. I think it would be a huge surprise to a lot of practitioners to say a termination order in district court, it's not final, you can't appeal that. And I will push back a little bit that finality in adoption cases doesn't always happen. And I can give like a war story about that, but maybe it helps if I do. I mean, that I had an adoption case in district court where the parents' rights were terminated, and then about 2 weeks before the adoption finalization hearing, the parents separate, the adopted parents separate, and they start litigating a divorce case that subsumes that adoption. And so another year and a half happens before that adoption is final because they're litigating about who gets to adopt now. And parent, nothing to do with it. They're totally in the wind, in the lurch, get notice of nothing. And that's what the statute says. They're not entitled to notice. And so that's absolutely correct. In that the proper way to handle this is counsel is released from the case and they have no notice of what's happening. Anyway, and so that's why I think finality needs to happen at the time of termination. It's the only way a parent's substantive rights can be upheld. These are fundamental constitutional rights. This isn't a divorce bifurcation. And this is someone's constitutional right to raise their child. And it should be an immediate appeal.
All right, thank you, Mr. Richards, thank you. Mr. Nelson, very interesting issue. We'll take the matter under advisement and we'll get you a decision as soon as we're able to do so. Court's adjourned for now. Thank you.